All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Well, welcome back. 540-0580. Carl Rominger here answering your legal questions. You know, I'm an attorney here in the Mid-State. We have a general practice with a little of everything. Somebody asked me the other day, what does a general practice mean? Well, it means if you need a divorce, if you need a personal injury case done. Actually, I'm very proud of us. It looks like, you can't count your chickens till they're hatched, but we just took a case where somebody had $100,000 in insurance coverage, and we were able to kind of look everything over and determine that the insurance company was not being correct and actually denying them an additional $300,000 in coverage they should have. So now they're going to go from $100,000 towards their medical bills and their accident to $400,000 on just that one policy alone.
Wow.
Yeah, which is a big deal because the medical bills in the case approach $250,000. So they basically went from getting nothing to being able to at least get some of the lost wages recouped on top of the medicals.
Right.
So you want to make sure, Drew, you want to make sure you check those insurance policies right from the beginning.
You could be losing $300,000 if you don't.
Yeah, and it makes me laugh because I get these guys who go, "Oh, I don't need no lawyer. This personal injury stuff's easy. There's $100,000 in coverage, and they're going to give me $100,000, so I'll waste $25,000 on a lawyer for an attorney's fee." Well, first of all, a lot of times the medical bills or the other liens get reduced by the attorney's fee, so you don't pay the full attorney's fee. In fact, if $50,000 of it's going for medicals, well, the doctor pays half the attorney's fee. Okay, that's number one. Sometimes they pay all the attorney's fee. Number two, though, is do the math on that one. So if that guy had settled it himself and just said, "Oh, I don't really care. I can save all this money. I'll save $25,000." Well, first of all, he would have got nothing because he had discovered he had to pay back the entire medical bill. Nobody in the insurance companies were going to tell him that there was a policy interpretation that could be made. And we had to do, I had to do some homework, and then I had to run down some witnesses and do some things to convince the insurance company on the factual background. But the point of it is this: okay, so our fee is going to be some percentage of that. They're still way ahead on the entire deal,
right?
So anyhow,
I've had a lot of clients walk in with that concern. Not too many when the case is over.
Right. Think of, and again, without going into specifics, I mean, I think of one of your cases right now where you were working on a workers' compensation matter where...
That's getting close to being final.
Yeah, where they start at one number and they get, after a year and a half of negotiating themselves, get there, and then you double it into the six figures in another couple months, because the mere fact that there's a lawyer involved changes the entire gambit for the other side. But I could prattle on about that, but I just get so mad when people think they're going to save attorneys' fees, because I'm all in favor of attorneys getting paid. I mean, I'm going to be honest there, right?
Right.
But at the same time,
it's a win-win.
It's a win-win. That's right, and it's the same thing when. Well, anyhow, everybody's an expert at everything. That's why I don't change. I went to Jiffy Lube today. You know why? Because I'm not an expert on changing my own oil. And my brother yells at me about that because he says it's so simple to change your own oil. But as I've explained to him, I'd have to take my suit off. I'd have to go buy blocks. I'd have to buy a wrench. I'd have to figure out how to get under the car and find the thing. You know what I mean?
Exactly.
And for me, the transactional cost of running to the Jiffy Lube for 15 minutes was much cheaper, although he's technically right. I could probably do my own oil change for $8. Anyhow, Tim, you're on with Carl and Drew. Tim.
Yes.
How are you?
Hi. Just fine, Carl. I got a little hesitation there. Anyway, last week you were when I came into the program to listen, you were talking about a specific law firm that deals with elderly law.
Yes.
And I did not get evidently the full name, and I wasn't able to pursue it. Could you?
I'll get it for you again here. It's Keystone Elder Law.
Chief.
Keystone.
Keystone, okay.
Yeah.
Thank you.
Yeah, Keystone, and they're in Mechanicsburg, and the phone number is 697.
Okay.
3223.
3223. All right, Carl. Well, I certainly appreciate that, and we'll give him a call.
Yeah, and the other thing to tell you about those guys. Let me see here. Let me find his bio. David Nesbitt, who's the head of that firm, and then he works with another attorney, Jessica Fisher. But David is sometimes on with R.J. Harris in the mornings.
Oh, okay.
So, and I know him personally. He's a great guy.
Okay.
All right.
That's a good enough recommendation for me.
Well, you take care.
You have a great day.
Thanks.
Thanks, Carl. Bye-bye.
Now I'm going to make Nesbitt buy me a drink the next time I see him. 540-0580. Dan, you're on the air.
Hi, Carl. Thanks for taking my call. Question concerns a relative who has an outstanding medical bill of about $1,000.
Okay.
She cannot pay that. She does not have the money to pay even a portion of it, lump sum. So she has been paying $10 a month, and she notified the service provider, that that's the way she's going to have to pay off that debt.
Mm-hmm.
Is there any recourse on the part of the service provider if she, in fact, continues paying that $10 per month?
Well, if it was a non-medical debt, I think the answer would be very simple. Because, and the reason I'm going to circle back to this. I think hospitals and everybody have the same rights of collection as everybody else, but something sticks in my head that medical debts do get special treatment a little bit. And the theory being, I think, is we don't incur them voluntarily a lot of the time. That said, I do think ultimately they could sue her. I don't know if making a minimum payment on it is going to protect her or not. My inclination is to say no, but my hesitation is there might be some consumer-type protection law involving medical bills that would allow for it. Now, in my experience, as long as you go to the provider and enter into agreement with them, they'll gladly take it. However, $10 a month on $1,000, they may say, well, how about we do $10 a month for 6 months and then reevaluate our position,
Yes.
Okay. And that's what I was going to ask. Is that something that they agreed to, or just something that she said she was going to do?
And that was when Carl said that it was agreed to. They did not necessarily agree. They agreed temporarily until she filed an application with the state, and then provided the results of that Medicaid application to the provider.
Yeah. So they're being cool about it.
Yeah. They are thus far, yes. It's just that, if things turn out that Medicaid will not, it's an ambulance bill is what it boils down to.
Right.
So that's why I said it's a medical type expense. But so if they didn't agree to that, ultimately, if they don't agree to that, then that could be a problem for her.
Right. Ultimately, they can certainly enforce their rights.
Yes, sir. Thank you so much for your information.
All right. Take care.
Yes, sir. Bye now.
Always tough with those things,
Yeah.
People don't tend to incur them. And Drew, actually, I know you've been doing some work with folks who've got, behind on their bills and are looking at bankruptcies, but also looking at trying to, pay one creditor off at a time and work deals out. And I know that works pretty well too.
Yeah, absolutely. Especially, a lot of unsecured debts, credit card debt.
Right.
Absolutely. Absolutely.
All right, we're going to go to break here, 540-0580. When we get back from the break, you'll be talking with Carl Rominger and Drew Deo about your legal problems. Welcome back. Carl Rominger here answering your legal questions, 540-0580. Jay, you're on with Carl and Drew. What's going on, Jay?
Hey, how you doing, Carl?
Good.
We won't talk about Descartes or Pascal this week.
Okay.
But a previous caller was talking about the fact that somebody had gotten married and what happens to the property if it's not titled in this and a whole bunch of calls like that, and it sounded very complicated. So my question is, or idea is, you advise somebody who goes into business with somebody to have a business contract, a plan before they get together, so that if the business dissolves, a lot of those questions are settled. Marriage to me is nothing more than a contract with benefits or a business with benefits.
Right. A friend with benefits.
Well, whatever. So the idea is when you get divorced, you've got to get all this legal. You've got to get legal, not only legal help, you have to have court. The court divorces you, although there are religious courts. But you don't need that when you get married. I think maybe they should require a legal document, not a license. When you get married and a legal contract, I'm not too concerned with these clergymen. But for the business part of it, why not institute that?
We have them. They're called prenuptial agreements.
Yes, I was just thinking.
But they're not forced upon you.
Right, they're not forced upon you. That's correct. And it's interesting. And in fact, I was talking to a very prominent family law attorney last night who was at an event I was at. And he was telling me that in his estimation, and I have no reason to doubt it because he's the expert in the area, that Pennsylvania is actually the best state for prenuptial agreements if they're executed here, because we have some of the strongest black letter law that make them essentially bulletproof if done right. That becomes the big issue, though, because the law in that area is a little complicated and full disclosures are required, etc. You'd almost probably need some kind of legislative fix to make a simple prenuptial available to people of less than large means. In other words, most of the prenuptial agreements that we see executed are between very wealthy individuals who are trying to protect their family money, for instance.
And I'm suggesting that everybody, and you can call it a prenup, call it what you want.
Right, I agree with you. I'm just saying we would need something, because in order to do what I'm trying to say, though, is the investment that goes into making a quote bulletproof prenup is not $100. It's thousands of dollars, and
depending on your situation.
Right, and so that would mean we would probably need something, like a low end prenup that basically says, I'll keep my $2,000 Visa card debt, you'll keep your $3,000 MasterCard debt, I'll keep my retirement, you'll keep your retirement, and we'll split the house evenly, unless we'll buy it off of each other under the following terms, and that's the end of it, right?
Well, I'm a guy who's been divorced twice. We're fairly simple, but nevertheless, I guess I look at, and I'm married a third time, and I know it's all this romantic stuff, but I guess I look at it a little differently. Maybe we should. But it's really, what it is a legal contract. And well,
I was explaining to somebody the other day that my perception is this. The average couple does not have a prenup for two reasons. One is because they're the romantic notions. But the romantic notions are never going to be overcome by the money in most couples' existence, because there's just not enough money. So the average couple getting married at 23 or 24 doesn't think about a prenup because they really don't have a lot. And if you don't have a lot and you approach your spouse about signing a prenuptial agreement, you're probably not getting married, right?
Well, but I'm saying in some of these cases, when you talk to the one guy who it was already, somebody had already had a house, and then, so I guess got married and the person wasn't on the deed, and then the original owner died. A lot of that, I think, could be straightened out. Again, I just put this forth to shake up the WHP faithful.
Right.
That I just think marriage, in a way, should be, you can go to a priest, rabbi, or whatever, and I still think you should be required to go to a judge or a lawyer.
Well, it's always been, just so you know, I mean, we've always looked at marriage as a contract in the law. So it's always been a contract in the law. Now, interestingly, obviously, the rights of the parties have changed over time now that women are actually considered more than chattel, right?
Yeah.
But that's pretty much it. We've always considered a contract in the law. For what we've considered it in society is different. And, of course, the modern concept of romantic marriage is kind of new.
I'm a little bit tongue-in-cheek when I call, so...
I know.
Right.
Thank you, Jay.
All right, Carl. Take care.
Take care. 540-0580. Larry, you're on the air.
Carl?
Yep.
Okay, situation. My daughter has a townhouse, and she owned it prior to getting married. And the real estate agent is suggesting that she have her current spouse be at the closing and to sign some kind of document that he has no interest in the funds that will come to her at closing.
Yeah,
is
pretty standard.
That is standard.
Pretty standard. If you have a spouse or even a soon-to-be ex-spouse or or whatnot, and you own property and you're selling it, the closing agent, if there's a divorce going on, the closing agent's going to want to make sure that both parties to the divorce sign off on the distribution of the proceeds. Mm-hmm. On the other hand, if you're a happily married couple and only one party owns the property, the other side, the buyer's agent, in terms for title insurance, wants a disclaimer of any potential spousal right to waive any cloud that may create. So we quite often get this scenario where I've got a deed and it's from some guy to somebody else selling the property, and then he finds out his wife has to come in and sign, and they get all distraught and bent out of shape and keep asking me how come their wife has to sign, and I explain to them because the buyer wants to be sure that she's aware of this transaction and that she's disclaiming any interest in the proceeds, essentially.
So that is a fairly standard practice.
Very standard practice.
Okay. Well, now I know that he has stepped in and made some payments against the mortgage while the house was sitting empty between the prior renter leaving and the sale of the house. It was on the market for a year. So he, fair being fair, he would be entitled to be reimbursed for the payments he made on the mortgage.
Maybe, yeah. Maybe.
But
I'm not sure it's automatic. I mean, if we're in a divorce situation, right?
No, there's no divorce situation, although sometimes the marriage has its moments.
So he made payments, but why does he need reimbursed? Aren't they? They're a couple still? Am I not following something here?
Yeah. No, they're still a couple. It's just that sometimes the marriage ran through some turbulent waters.
Right. Well, it seems it seems to me they've just got to figure it out and get that signed.
But that would so okay. We hadn't heard of that being a protocol that is usually followed.
Right. No, it's fairly normal.
Okay. Thank you very much, Carl. Appreciate it.
Take care.
Bye.
Yeah, particularly if they're on again, off again. I mean, that's going to give everybody a little, concern. Plus, if one of them lodges a divorce, think about it this way. Okay, there's a theory that says that in order to pass good title, a husband or wife who owns property separately can pass good title without the spouse's signature. Does that make sense to you, Drew?
Yes.
Now, a lot of title agents and a lot of underwriters will not accept title unless both spouses sign off. And so the one signs off on the deed and the other one basically just signs an acknowledgement on the deed saying they're waiving any spousal interest.
Right.
That and the reason they require that, quite frankly, is some of them mistakenly believe that, and I say mistakenly believe because I agree with some other attorneys who take the position that a spouse can do that. In fact, there's a case here in Pennsylvania that says that a spouse can transfer property without the spouse's signature and not create a cloud on the title. That said, what if on day one of issuing the title insurance, you've already done your title search, right?
Uh-huh.
And then 3 days later is the closing. And at the closing, the spouse does not come in and sign off on the spousal waiver, right? But on day two, they've lodged a divorce complaint at the courthouse, which they haven't yet served on anybody, but it's definitely at least lodged and in the process of being served. Or maybe it does get served on the seller, but the seller chooses not to tell the buyer about it that morning. Point is, getting both signatures means it's irrelevant if a divorce was filed or not, right?
Right.
So to the extent that it's required, I would disagree. To the extent it's a best practice, I would concur.
Right. Advisable, yes. Required, maybe not.
Maybe not. Now, interestingly, like I said, most title carriers will not allow that to go through. And I'm only aware of one reputable title company here in central Pennsylvania that will do that. Yeah. And we've been able to steer some sellers to steer their buyers to that company if that's the issue.
Right.
Anyhow, that's getting a little technical, I'm sure, for the audience. But let's see. Jerry, you're on with Carl and Drew. Jerry. Hey, Jerry.
Yeah, hi, Carl. Thanks for taking my call.
No problem.
About 5 years ago, I attended a one-year certification school in New York for nutrition counseling. And the school, towards the end of the year, due to the school failing to notify me properly about an online test, It cost me one of my certifications, and there were some other issues. But I proceeded to. I wrote not a derogatory. I wrote a negative review of them on an online site.
Mm-hmm. Mm-hmm.
And yesterday I got a phone call from their attorney threatening to sue me if I didn't retract my comment.
Gotcha.
And I've researched it a little bit. Are you familiar with the anti-slap law?
Yeah.
Can you tell me a little bit about that?
Well, the concept of that is is to prevent people from slapping lawsuits on people to stifle them.
Mm-hmm.
Because what would happen is somebody would say something, a big company would roll in and just kind of grind you up.
Right.
And the anti-slap laws are a fight-back measure there.
Mm-hmm.
I don't know if Pennsylvania has one or not.
From what I read, they do, and so does New York as well. So I appear to be covered. I'll tell you why I'm calling. They really got my goat now, and I'm actually thinking of going back and adding to my complaint. So I want to make sure.
What did they threaten to sue you with?
I guess from what it sounds like, damage to their reputation, loss of business, like that. And I want to be clear. I wasn't derogatory I wasn't personal in my complaint. I just spoke my experience and my opinion about it.
Right. No, I mean, if you're listen, truth's 100% defense. So
right, that's what I was just going to say. If it's truthful,
yeah,
I think you're fine.
I have nothing to worry about.
The thing that really ticked me off, just as an aside, is nobody in authority there wanted to even talk to me about it at the time. That's what really ticked me off.
There's an old adage about that, which is, sometimes you have a dissatisfied customer. If you just get them on the phone and sue them, things go a lot smoother than if you leave them out in the wilderness.
So, anyway, I as I said, I was thinking of adding to my comment.
Well, Jerry, as long as you never complain about this show, you'll be fine.
Right.
All right, I got to let you go. We got to go to break.
Thanks, Carl.
540-0580. It's one of my favorite songs, Drew.
Oh, yeah.
Now, can the Smoked Meat play a song like that, or how's that work?
We do a couple. We throw back to the 80s every now and then.
We're fading in and out there, brother.
Oh, yeah. We play a little bit of everything.
Oh, yeah. So, Drew, tell us about your band real quick. So where are you playing next?
Well, we just did a show last weekend in Middletown again, and we're trying to actually organize a little concert on the Susquehanna River. Call it Jam on the River or something. Somebody else may have already taken that name. I don't know. But we're trying to organize maybe a little festival, a few different bands.
So what you guys are going to do is
River.
basically go out on an island and all camp out there and get busted by the police like they did a few years ago.
Yeah, exactly. It's very similar to that case.
Oh, yeah. It's a great idea. I run that by me again at the office, would you? 540-0580. Laura, you're on with Carl and Drew.
Hello?
Yes, Laura.
Oh, gosh, I didn't hear my name.
It's
I
okay.
just heard a blank. And anyway, I'm out driving, and it's rare that I even get to hear your show, and I love it. But you were talking earlier about, I guess, a car insurance issue. And
right.
I don't know if you even remember me, but I'm an insurance agent, and I don't recommend that anybody have anything less than $100 or $300 for bodily injury and property damage, because I just don't think it's responsible. But the point of my call is that I have a friend who will just say, I don't know, was going through a dark time.
Right.
Last year, and found himself had drank too much and hit a lot of things. And so he called me the other night, and it's already been worked out. I think the charges may have been dropped, but he got a call the other night and said that his insurance company's calling him, and he has Geico, and his insurance company's calling him, and they want to talk to him about this, this one spot.
Right.
And I asked him what his limits are. And I'm not a lawyer, so if I try to give him legal advice, I could lose my license. But he told me that he has $5,000 in property damage. It's just like, oh God. But
bankruptcy
2 questions
time.
He asked, what?
Bankruptcy time.
Yeah. But the question that he asked me, was twofold. He said, one, should I take the call? And I said, well, you know what? If it's your insurance company, they're supposed to be on your side.
Right. And he has a contractual duty to cooperate with their investigation.
Right.
Exactly. And he was like, well, I mean, like, why are they calling? And I said, because they do. Because when a claim is filed, that's procedure. They have to contact.
Well, imagine this one. My brother had one where somebody said something came off the back of his truck, you know?
Right.
And the insurance company calls him up, and he says, no, I wasn't even in that vicinity at that time. This is one of these false claims.
Right.
And what happens is they check it out, and I guess eventually determine it was a false claim. Now, if he'd have just dodged them at some point, you know, to become a claim against him.
Right. Now, you know, my friend is saying that his attorney advised him to not speak to them.
Well, here's the question.
And I didn't understand that. I just...
Pending,
yeah.
And your friend may be confused because let me explain how this generally works. We get this all the time.
Right.
Guy's got a criminal problem that involves damage to some kind of property.
Right.
I got an insurance company wants to talk to him, maybe even his own.
Right.
I call him up and I say, listen, the government, the Commonwealth, whoever is trying to, roast this guy. So he can't really give a statement yet. But here's a letter that'll say as soon as the criminal action is resolved, we will cooperate and give you a statement.
It was resolved. So
and so he's probably confused because his lawyer probably told him, don't talk to anybody about this, including the insurance company. But if he went back to his lawyer now, his lawyer would probably say, okay, everything's closed now. You should cooperate. Now, the other danger is if his lawyer is exclusively a criminal practitioner who's unaware of some of the insurance nuances in the law in that area, he may not occur to him. Yeah, being safe, he's like, just don't talk to anybody about it. But he's not thinking it through, going, oh, but yes, right, you do have a duty, and you may lose your coverage if you don't.
But there's another side to it, too, and this is my second question.
Okay.
And, property damage limit $5,000, and he's like, oh, it can't be that much. And I was like, oh, my God, you have no idea how quickly it adds up. But, so it's all been worked out, everything's done. Now, he could be afraid to talk to the insurance company because of, the fact that it might exceed $5,000. Also, given that there was no, verdict or prosecution or conviction on this incident, is there any legal recourse for this person to claim that my friend was the perpetrator?
They can still sue him civilly. It's like the O.J. Simpson case.
Okay, well, as of now, it sounds like he's just trying to call this guy's insurance company.
Yeah.
But, I mean, is there any... And I told Jeff, and again, I said, I'm not a lawyer, and I shouldn't even go this far, but, from what I know, there is no way for this man to, he can file a claim, but in the end, I would think that your insurance company is calling you because they want to get your side, and maybe you could just say, I don't really have anything left to say about it. And, is that...
he should tell... I think he's a duty to cooperate, and he can say, I have no knowledge.
Well, yeah, but or just like, I don't really have any comment on that. It's been decided, and so I don't know what to tell him.
My advice would be to talk with him, but just don't, throw yourself under the bus if you can avoid it, but tell the truth because you're contractually obligated to do that.
Now, what can this guy do if I don't have all the facts and say this person, does have more information?
Mm-hmm.
What can come of, say, they max out on the $5,000?
Well, then he could they could sue him for the additional amount.
That's what I thought.
And then ultimately they have to get a judgment against him. They have to win that in a civil case. Now, there's a reason the criminal case probably died because maybe the facts aren't that good.
Because there was no. It happened in December,
right?
And it's just So, but in any event, I didn't really know what to tell him. And you were talking about insurance earlier, and I was just curious as to how you would advise him.
Yeah, I would advise him to cooperate, but I would do so, carefully and not put myself out there. But at the same time, he has to tell the truth to them, and he has a duty to cooperate, or he could lose his $5,000 in coverage.
Right. Well, he started to freak out, and then he tells me that he put a letter in this guy's mailbox that filed the claim. Oh, I know. I'm like, Jeff, come on. Oh gosh, I said his name. But oops. But yeah, I mean, I was just like, why would you do that? Why in the world? But I mean, he feels guilty, you know. I mean, he feels upset about it, and so he's thinking he might want to settle it outside of insurance.
Right.
And he's assuming all this stuff, and yeah.
We call that an admission, what he did.
Exactly.
I had a case where somebody shot somebody allegedly while hunting with some bird shot that fell in the lady's eye who wasn't hunting with them, and he wrote this apology online on the huntingpa.com.
Oh no!
Which really wasn't directly. In other words, it wasn't like, yes, I did it. It was sort of like, you know, I might have been the guy that did it, and I feel bad about it if I was. So it wasn't a complete confession, but it certainly wasn't helpful. And magically, at the first hearing, guess what the game ward had right in his hand? The printout. And I'm like, what is that? Well, I felt bad. I want to let people know I felt. Like, but what did you feel bad about? You didn't do anything. Well, but it might have been me. I mean, I don't know. I don't think it was, but I felt bad. And I'm like, well, guess what? Why don't you feel bad on your way to jail?
Yeah, I know. So, all right. So I will. Yeah, I mean, I'll tell him that you said to. You know, to call.
Tell him I said, man up, call the insurance company, give him your statement, and be done.
Thank you.
All right.
Okay. All right. Bye.
Bye. What do you think of that one, Drew?
Never letters in the mailbox.
Yeah. You got to put postage on them, too. I don't think you can use the government's mailbox without postage. I don't know. Everybody seems to think it's mail theft when somebody else opens somebody else's mail. I get that call. Isn't it mail theft because they open my mail? And I'm like, dude. If some mailman puts a pile of mail in my mailbox and I'm going through it, I usually turn the envelopes over to the backside because they're easier to open that way. So, you know, I might miss whose name's on the front, but you're right. I mean, I probably shouldn't stuff it in a rat hole and never forward it to the guy it belongs to. And of course, if I'm getting 85% his mail, then maybe I should do something about it. But, you know, an occasional piece of mail misopened is not the federal crime that everybody seems to think it is in the context of a divorce case, a custody case, or a contract dispute.
Exactly.
All right, when we come back, we're going to talk with John about taking discovery on speeding tickets, 540-0580. I'll see you guys in a minute. Welcome back. Carl Rominger here, joined by Drew Deo. Drew, how are you, brother?
Not too bad.
Thanks for holding with me. Listen, we're taking people's legal questions here, but of course, throughout the week, if you need to get a hold of me, Drew, Steve Snyder, Vinny Manfredo, Robert Culling, and now we've got Lee Mandarino in the office, who just passed the Pennsylvania bar but was already admitted to the state of New York. So Lee's now going to be able to float in and out of Pennsylvania courts as well as New York courts. And, of course, as you know, Steve's admitted in New Jersey, so we've got a 3-state coverage right now. Anyhow, if you need to get hold of any of us throughout the week, you go to RomingerLaw.com or the phone number 717-241-6070, 717-241-6070. And again, RomingerLaw.com. You can find us, read about us. We do post some nice articles on there. So, guys, check it out. And like I say, throughout the week, if you need a lawyer, feel free to call any of us. Hopefully, you know, I've got Drew on the air here. You've got to know him a little bit. And the other guys like to come on, too. So they're like my own little personal whack pack. John, you're on with Carl and Drew.
Hey, Carl and Drew. I do have a speeding ticket question. Actually, I do want to ask about the discovery, but I have a quick question on a red light camera.
Yeah.
Don't I have the right to face my accuser in court?
Yes.
Yes, you do.
So if I got a red light ticket, couldn't I, how do I speak to the red light camera if it's accusing me?
Well, that's the interesting question. It would be somebody. Now, I'm not certain how that's going to work. Your accuser is going to be the person who collected the evidence, okay? Right?
Right, but they didn't physically see it.
They didn't physically see it. That's correct. But here's my question for you then. If you robbed a bank and it's on video camera, right, and the only evidence that you were in the bank robbing it is the videotape, same thing, right?
Could be, but I just thought that was a...
Yeah, no, that's an interesting question because you're actually getting to something here, which is what is an observation and testimony or a testimonial statement of somebody versus just evidence, right?
Right.
And here, this is just evidence. Your accuser is going to be somebody. It's going to be the police officer or the traffic department or somebody. And interestingly, while you have the right to confront your accuser, right, you won't have much to confront him about. Hey, Mr. Accuser, what's that? Well, that's a video that I pulled, or a red light camera that I pulled. Okay, well, how did you pull it? And you can talk to them all about how it works and how they pulled it and how accurate it is. And they can answer all your questions, but if it gets admitted, you're probably going to get convicted. So you need to wear the giant bunny hat like the guy does out in California.
Okay, so I did get a speeding ticket, not from a red light camera, but from actual speeding. So,
right.
Can I take discovery on this? And
you can. In any summary matter at the Court of Common Pleas, not the DJ level, but at the Court of Common Pleas, the rules of criminal procedure as they apply to discovery and motion practice apply. Although it's not clear what the deadlines are because there's no arraignment to trigger the deadlines, okay? Instead, what I do is I just file a letter with the DA, informal discovery, and if they don't provide it, then I file a formal discovery motion.
So I can't do it at the district justice level?
Usually not, in my opinion, is discovery, because even in criminal matters, since you follow the criminal rules, and you go outside the summary rules, if that makes sense.
Well, yeah. I mean, I guess if he used a radar gun, this happened to be a new cop. I just happened to know that.
Right.
So if he used a radar gun, who was he trained in it? Who trained him? Was the guy who trained him?
Right, and that's all stuff that you can ask him about. But in terms of getting discovery ahead of time, you're definitely going to have to be at the Court of Common Pleas.
Okay. So if this fails, or if they find me guilty,
you file the appeal and go again.
Okay.
And what exactly are you looking to do? I mean, is this just something that you absolutely are not going to ever plead to, or are you willing to negotiate a little bit, or what?
Yeah, I mean, it was over Easter weekend, and I drive for a living. I've never had a ticket. This is going to sound really stupid, okay? But I had to pee, and I was speeding, trying to get to the next gas station, so I didn't pee my pants.
And let me tell you what the law says on that. The law says
it's an emergency.
Well, no, I hear Drew. When you're claiming necessity or emergency, you have to pick the crime of lesser evil. Okay. Now, there's a case that says that public urination is a lesser evil because you're less likely to hurt somebody than if you're speeding. But in this day and age, where everybody and their brother thinks that everybody and their brother is a child molester or a pedophile or a rapist. I would be afraid to pee along the side of the highway because I would assume that somebody would automatically assume I'm some kind of flasher.
Right, and then you're open lewdness guy.
Right, then you're open lewdness. So I'm not sure the logic of that court case is completely as easy as the judges there would like you to believe.
No, the type of logic, maybe the judge doesn't buy it. It's not a real legal justification, but maybe it's enough that if you didn't have to, you don't have any tickets
right.
to pass.
Did you tell the officer you had to pee?
Right. Tell the officer.
I was embarrassed, and I didn't. I was respectful. I didn't
right.
do anything. That I didn't answer any questions either.
All right. Well, here's what you need to do. You need to go and negotiate. We're not going to give you the secret negotiation codes or anything like that. But see what you can do. But I guarantee you, under those circumstances, if you are polite and respectful, we can get you out at any points.
Yeah, that's what I was going to say. If you're concerned about the points, that might be one you can negotiate with the officer. And if you don't have a bad traffic history, he'll probably work with you.
This is my first one. No priors or anything else.
Yeah. Well, John, get in there, brother. I got to take a couple more calls before we run out of time here.
Okay. Thank you, guys.
All right. Bye. Barbara, you're on with Carl and Drew.
Hello?
Hello, Barbara.
Hi, how are you?
Good. What's your alimony question?
Alimony, actually. It was that is sort of a joke. How do I get legal help when I'm involved in a situation that's complicated? It involves a group of men who are sort of invading my privacy, preventing me from moving forward with my life. I feel like I'm being held hostage. For 7 years, in 7 years, I've moved 4 times to get out of the situation. I sort of have a disability which prevents me from actively, returning their aggression with something verbal and stuff like that. I mean,
So, are you married?
No,
okay.
no. But I feel like I've been married to this group of men for 7 years. I mean, they keep the situation involves a lot of wacky situations. They know a lot of my private life. I'm actually under surveillance. They know where I'm going around the community. I've tried going to the police. Everybody thinks it's a joke.
Well, Barbara, here's
not a joke to me.
My advice would be you're going to need to get proof of that somehow. So I would recommend you perhaps buy yourself a video camera. They're very tiny these days, and carry it with you, and perhaps you can catch them in the act, and that will help you persuade the police as to what's going on.
Yeah.
I would definitely go that route. 540-0580. Bob, you're on the air.
Okay, I had a question about the leases
yes.
that are made. And does a landlord required to hold a security deposit and put it into an interest-bearing account after any time period? And also, does he have to keep it in like a separate escrow account?
I think that they are supposed to keep it in a separate escrow account. And I do think I don't know if it has to be an interest-bearing account or not.
Yes, I don't know.
We don't know the answer.
Oh, okay. I thought this was kind of a out-of-the-way question, but it comes up on leases, and I looked at a lease that someone has, and I didn't know what the law was. So
yeah, and the short answer is with the interest rates being as low as they are, it's almost de minimis right now if it's only a year or two, but there are times when it could be a lot of money. 540-0580 is that a talk line number? Because we're out of time, aren't we, Drew? Yeah, well, we're out of time, Drew, so I've got to let you go. Anyhow, guys, next week we'll be here live answering your legal questions. Go to Rominger Law in the meantime or call us at the office, 241-6070. See you next week.